Hello and welcome to SENDIASS Rutland. Making a complaint about a nursery, school or college. Why you might complain. What is the best endeavours duty? The legal rights to inclusive education. The complaints process and any next steps. You may wish to complain about a nursery, school or college if it is failing to put support in place for a child or young person's special educational needs, or SEN. A child or young person is not being included in the activities of the school because of their SEN. A child or young person has been unlawfully excluded if they are sent home without following the correct procedures for an exclusion, or if a school has put a child on a part-time timetable. For more on exclusions, you can watch our YouTube video by following the link in the description below. This list is not exhaustive. Nursery schools and colleges have legal duties to support children and young people with special educational needs. SEN support. Nursery schools and colleges should identify and support children and young people with SEN and/or disabilities. Children and young people in mainstream settings may be supported from within the school or other settings' own resources. This means they receive special educational provision, additional help or support, but they do not have an Education, Health and Care Plan or EHC plan. This additional support is called SEN support. The nursery, school or college should record what SEN they have identified a child or young person as having, what outcomes they expect the child or young person to achieve, and what provisions is being put in place to reach those outcomes. This should be written down in a SEN support record. One of the key duties is for the nursery, school or college to use their best endeavours to support children and young people with SEN. This duty applies to mainstream settings and alternative provision settings. This means doing everything that could reasonably be expected of them. Where a mainstream nursery, school or college cannot meet a child or young person's needs, they should request an EHC needs assessment. This might be because they don't have the expertise or funding to identify those needs fully, or to identify the provision or support the child or young person requires. Alternatively, it might be because they know that the child or young person's needs are, but they cannot make the necessary provision from their own resources. If the school can show that the child or young person has or may have SEN, and that they may need support through an EHC plan because the school cannot provide the support they need, the local authority must agree to carry out an EHC needs assessment. This may lead to the child or young person being given an EHC plan. Best endeavours duty. A key duty for certain settings is the duty to use their best endeavours to secure special educational provision for all children or young people for whom they are responsible. This duty applies to mainstream schools, including mainstream academies, maintain state-funded nursery schools, 16 to 19 academies, alternative provision academies, further education institutions, and pupil referral units. Note that this does not apply to special schools or independent schools. Best endeavours, the law. The law says, if a registered pupil or a student at a school or other institution has special educational needs, the appropriate authority must, in exercising its functions in relation to the school or other institution, use its best endeavours to secure that the special educational provision called for by the pupils or students' special educational needs is made. Section 66 of the Children and Families Act 2014. The appropriate authority means the governing body, proprietor or management committee of the school or other setting. The legal duty is directly on them as a body and not the head teacher of the school or principal of the college. The governing body, or equivalent, is in a position to effect change as it is responsible for the appointment and performance management of such posts. Best endeavours, details. These duties apply to all children with SEN, whether they have an EHC plan, a statement of SEN, or neither. This means that the governing body, proprietor, or management committee must use their best endeavours to secure the special educational provision. Using best endeavours means doing everything they can to meet the child or young person's SEN. There are further details of what this might include in the SEN and Disability Code of Practice 2015. It is a proactive duty that requires the appropriate authority to inquire and ensure that the nursery, school or college is actually making the special educational provision that children and young people require. It is not enough to accept the word of a school's head teacher, for example, that an adequate record-keeping process is in place. The school governors should ensure that it is. The best endeavours duty can require schools or other settings to obtain specialist help, such as speech and language therapists or educational psychologists. The code also includes a requirement that, whereas a pupil continues to make less than expected progress, despite evidence-based support and interventions that are matched to the pupil's area of need, the school should consider involving specialists, including those secured by the school itself or from outside agencies, paragraph 6.58 for schools or 5.48 for early years settings. For children or young people with an EHC plan, the best endeavours duty also applies, but additionally the local authority, or LA, has an absolute duty to secure the provision in their EHC plan. It is not enough for the local authority to simply try their best to provide it. The local authority must ensure that it is provided. The SEN Information Report. The governing bodies of all maintained schools and nursery schools and the proprietors of academies must also publish a SEN Information Report. This report will generally be found on the school's website. The report must contain details of how the school identifies children with SEN, how it makes provision for children with SEN and the facilities available to do this, details of the Special Educational Needs Coordinator, SENCO, and, importantly, what arrangements the governing body themselves have for dealing with complaints from parents about their children's SEN provision. This should include the name of the governor responsible for SEN matters on the governing body. This report will therefore contain information which should help a parent check whether the governing body or proprietor is complying with its best endeavours duty, and to take steps to complain if they feel that they are not doing so. The Code of Practice. Nursery schools and colleges have clear duties under the SEN and Disability Code of Practice 2015, or the Code. This contains guidance on what they should be doing to identify and support children and young people with SEN. The Code applies to all settings except wholly independent schools. Nursery schools and colleges must have regard to the Code. This means that they should do what it says or be able to explain why they have not done so and what alternative has been put in place instead. Inclusive education. A child or young person has a right to an inclusive education in a mainstream school or college with their typically developing peers, if they want it. This includes being included in the activities of the school. Mainstream schools and maintained nursery schools, but not further education institutions, must ensure that children with SEN engage in the activities of the school together with children who do not have special educational needs. The school can only exclude them from activities if it is not reasonably practicable for them to be included, being included would prevent them from receiving the support they need, or being included would prevent the efficient education of other children or the efficient use of resources. These conditions are set out in the law, Section 35 of the Children and Families Act 2014. Therefore, a child can only be excluded from activities if one or more of these conditions applies. The Equality Act 2010 is also useful if a disabled child or young person is being excluded from activities. Their exclusion could amount to disability discrimination, and you can find our resources on disability discrimination in the description below. Inclusion is a fundamental principle underpinning the Code. See paragraphs 1.24 onwards. Schools, education and training providers are required to make accessibility plans outlining how they intend to make their setting more accessible for disabled pupils. You can find out more information on this on Alliance for Inclusive Education's or ALFI website. If a lack of resources is a barrier to inclusion, then this may be evidence that more or better provision is required, for example via an EHC plan or amendments to an existing EHC plan. Independent schools. Most of these duties, aside from those arising under the Equality Act 2010, do not apply to fully independent schools or other institutions. Alliance for Inclusive Education, ALLFIE. The Alliance for Inclusive Education's website also has resources which relate to discrimination, including a report on education and training providers' duty to develop accessibility plans to address physical and other barriers to disabled pupils' learning. You can find the link in the description below. Complaints process. If your child has an EHC plan, but the provision set out in it is not being made, then you should normally make a complaint to the local authority rather than the school. You can watch our video on complaining to the local authority by following the link in the description below. If you believe that the school are discriminating against your child as a result of their disability, you may wish to consider making a claim for disability discrimination. The link for our video on disability discrimination can also be found in the description below. Making a formal complaint. The first port of call for complaints about schools should usually be to the school itself. This applies both to maintained schools, academies and independent schools. The only exceptions would be, for example, if you feel that your complaint will not be given a fair consideration due to conflicts of interest. The first step is to follow the school's own complaints procedure. Schools must have a procedure for parents to complain by law. What should the nursery, school, college be doing? The appropriate authority for the setting, the school governors or equivalent, has a legal duty to use their best endeavours to secure special educational provision for all children and young people with SEN for whom they are responsible. This applies whether or not the child or young person has an EHC plan. It does not apply to independent schools. Children and young people without an EHC plan should receive SEN support. When should I complain? You should speak to the class teacher and SENCO about your concerns and ask them to discuss the implementation of SEN support with you. If your child still doesn't receive the support they need, you may wish to make a complaint. If your child has an EHC plan and the setting is not delivering the special educational provision specified in the plan, you should raise this with the school, but direct your formal complaint to the local authority. You could use IPSI's model letter, which you can find in the description below. Who should I write to? You should follow the school or college's internal complaints procedure. Details should be on their website. Your complaint is about the appropriate authority because this is who the law says must comply with the best endeavours duty. Who the appropriate authority is depends on the type of setting. For a maintained school or nursery school, it is the governing body. For an academy school, it is the proprietor, for example, the trust. For a pupil referral unit, it is the management committee. For a further education or sixth form college, it is the governing body or board. Check the school or college's complaints procedure to see who you should direct a complaint about the appropriate authority to. You can use IPSI's Best Endeavours model letter to help, which you can find in the description below. If your complaint is about something else, for example the conduct of a particular member of staff or an incident at the setting, the school or college's complaint policy should say who you should direct your complaint to. When will I hear back? There is no fixed time in law, but the school or college's complaints procedure should set out how the complaint will be dealt with. It would be reasonable to allow 2 weeks for a response during term time, or longer over the Christmas and summer holidays. Remember to keep a copy of any letter or email you send. If you don't get a reply within 2 weeks, or if you need further advice, you can get in touch with an organisation such as SENDIASS or IPSI for support. Next steps. If you are not satisfied with the outcome of your complaint, the next steps depend on the type of complaint you are making. If you are complaining about a maintained school, you can complain to the local authority. Not all local authorities will look into school issue complaints, particularly if they feel it can be addressed within the internal school management system. However, local authorities do have a specific power to intervene under Section 62 of the School Standards and Framework Act 1998, where the behaviour of certain pupils is severely prejudicing the education of other pupils. This is relevant where there are bullying issues the school is failing to deal with, and you can read more about this on the Child Law Advice website. If this doesn't resolve matters, or if you are complaining about any other type of school, including an academy or further education institution, the next stage is to complain to the Department for Education, and you can find our resources about this in the description below. If you want to complain about a nursery or early years setting, this is not dealt with by the Department for Education, and so the next step is to complain to Ofsted. If your complaint is about data protection or a nursery, school or college's failure to provide you with information you are entitled to, you should complain to the Information Commissioner's Office, or ICO. You can complain to the Local Government and Social Care Ombudsman if your complaint is about A school failing to make the provision in the EHC plan despite having the resources to do so, B, the process is followed by an independent review panel following an exclusion, or C, the process is followed by an admissions appeals panel. If it is not appropriate to pursue any of the above routes of complaint, for example because the matter is serious and urgent, you may need to consider judicial review. SENDIASS can offer support and advice. Email us on info@sendiassrutland.org.uk. Call us on 07977 015 674. Facebook us at SENDIASS Rutland, or contact us on Twitter at SENDIASSR.